to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to Our Curious Amalgam, the podcast from the American Bar Association's Antitrust Law section. My name is John Roberti. Today's topic is How Far Can I Go? EU Competition Law and Distribution. Companies that want to sell their products to consumers have to take it down through a number of levels of distribution. And for many reasons, those companies may want to have some control over how the product is distributed and even how it's sold. In an earlier episode, we talked to an American expert on distribution law and learned some of the ins and outs. And today, we're going to speak to a European expert and learn a little bit about the contours there and how they may be different from the American system. My co-host today is Matthew Hall. Hi, Matthew.
Hi, John.
Matthew, what are we going to talk about today?
Well, as you say, John, there are some very distinct issues in EU distribution law, which are pretty different from some of the US issues. Also, it's fair to say that the European Commission and all the national regulators are very active in looking at distribution issues, in particular online selling issues. And there's been a lot of case activity and, frankly, changes in how things are looked at here. Also, it's important, I think, to say that EU competition law influences a lot of other regimes around the world. So it's good to get an understanding of the EU, which can be applied elsewhere. And finally, the European Commission is currently looking at changes to the overall framework for the distribution rules in the EU. So there's a lot to talk about.
Great. Well, who's our guest today?
Our guest today is Jen Marsh. Thank you for joining us.
Thank you for having me, Matthew.
She's a partner here in London with K&L Gates, and she deals with all aspects of EU and UK competition law and commercial agreements.
Well, great. Jen, welcome to the program.
Thanks, John.
So, Jen, I mentioned that there's going to be some changes to the basic framework, but could you just take us through what is that basic framework when you're analyzing distribution agreements in the EU?
Yeah, well, to start at the really high level, we have the equivalent of, I understand, Section 1 and Section 2 in the US. So we have the Article 101, the prohibition on anti-competitive agreements. That is, I would say, most relevant to looking at a vertical agreement like a distribution agreement. But we also have Article 102, the prohibition on an abuse of dominance, which I would say is more actively enforced as compared with comparable provisions in the US, and enables you to look at unilateral conduct. So when a dominant company imposes a distribution system as a unilateral act, is that compatible with competition law? Or is there anything sort of abusive about it? Specifically in relation to vertical agreements, because of course Article 101 and 102 cover many different areas. It covers including the cartel behaviours. But specifically on verticals, we have the vertical block exemption at the European level. And if you fall within the criteria of the vertical block exemption, then you can be basically confident that your agreement, such as your distribution agreement, is compliant with competition law.
And when we talk
as an advisor, I find that the vertical restraints block exemption you just mentioned is probably the most common document we look at.
Yeah.
Because of its application to all types of vertical arrangements.
Yeah, absolutely. It's I think it's a really helpful safe harbor. The key provision often is the market share threshold. Yeah. So as you know, being below the 30% market share threshold means that you're always looking, really, if you're in that level, to benefit from that vertical block exemption and get that certainty. Because as you know, we no longer have the system whereby we can notify agreements to a competition authority and get a gold star that it meets its compliance compliant. So in this sort of self-assessment world that we've had for some time, the safe harbors are the best way to ensure you're compliant.
Yeah, and people often refer to 30%, and as you say, there is an actual reason for that in the legislation.
Yeah.
But people often talk a lot about so-called object and effect restrictions and hardcore. What is that all about?
Well, it's not too dissimilar from your per se versus rule of reason in the US. So object being in some ways equivalent to per se and effect being rule of reason. There are some differences, but object is essentially this behavior, this agreement is so obviously anti-competitive, so obviously problematic, we don't even need to look at the effects. A cartel, you should be able to take enforcement action against the cartel before you can even see the agreement implemented and see any effect on the market. And that's sort of a second nature. Effect is, let's look at the effect. Show me the anti-competitive effects on the market. So a higher threshold for the authorities to meet.
So in the vertical context, as today we're talking about, I think the classic object restrictions or kind of automatic infringements are usually seen as RPM, resale price maintenance, and similar activities. And also particularly relevant to the EU are your cross-border trade restrictions. And
yeah, I mean, both of which I think can be a little surprising to American clients if they're not too familiar with the EU legal regime. I know there's a much more permissive approach, varies by state, but more permissive approach in the US. Whereas here, as you say, resale price maintenance is essentially a by object infringement. You cannot tell your reseller what price to charge a product. So you sell your product to the reseller, and then it's up to them. Your product is in their hands. You can make recommendations, set maximum prices, no minimums, no fixed prices, which is a tough one coming from an American background often. And secondly, as you say, the geographic limitation, which I guess again is a big difference going from the US to the EU. That our competition law has, if you like, this additional goal that it's always setting out to achieve, which is the single market imperative. Part of the function of competition law in the EU is to enhance cross-border trade. It is seen as a pro-competitive thing if you're encouraging trade from France to Germany. So that means you have to be very careful about putting territorial restrictions in your agreements here. Not so much, don't sell outside the whole of Europe, but yes, don't sell outside France. That needs a careful look.
Yeah, absolutely. So I think it's also interesting to look at agency. This is a concept where one entity is acting on behalf of another and not actually signing the agreement, but if you like, introducing the customer to the principal. That's sometimes a useful kind of, if you like, opt out or get out of some of these rules, isn't it?
Yeah, I mean, in a way, it's an extension of the fact that you can tell your subsidiary what to do. When we say you cannot tell a reseller what level to price at, well, if that reseller is your subsidiary, then yes, you can, because in competition law, we look at corporate groups holistically. And agency is meant to be an offshoot of that. That your agent is essential, is as it were your left arm. They're meant to do your bidding, and the counterpoint to that is that they don't take on any risk themselves. So if it's very much not the case that you can structure that you're thinking of something. Oh, let's do it as a distribution agreement, but then you think, in fact, this RPM thing, let's find a way around it. Let's just change the payment structure so it's a commission, and then we can tell them what to price at and where to sell around Europe and so on. No, it's about who has the real risk in that relationship. Does your agent have the credit risk if your final customers aren't paying? Do they have the risks of setting up in that market? Or in fact, are you the brand owner bearing all of that yourself? In which case, yes, there is this helpful exemption for agents.
And then you can tell the agent what to price at, where it can sell, to whom it can sell without any problems. So selective distribution is another big issue in the EU when you're looking at distribution of high-tech equipment or luxury goods. And a lot of that feeds into the discussion at the moment I mentioned earlier about what changes there should be to the overall regime. What is selective distribution all about?
So selective distribution is a tool we have that does in fact give brand owners more control over how their product goes to market. There's a lot, I would say, in the EU that means they might feel they have less control. This is a mechanism to give them some of that back. What it essentially does is enables a brand owner to say, I want to approve whoever's selling my product. Even if I'm not selling them to them direct, if they're getting the product elsewhere, everyone has to be approved by me to be a reseller of this product. And typically it's been used for luxury goods and for high-tech goods. The thinking being that for those product categories, it's appropriate to worry about the brand environment. If you think of a luxury brand environment and the amount a brand invests in its marketing and advertising strategy, then it needs to protect the environment it's sold in. Not necessarily, or definitely not justifying sort of an online sales ban. But again, is your online sales presence has it got the appropriate aura of prestige and luxury that brand is invested in? And similarly for the high-tech products, it might well be appropriate to have a stronger pre-sales and after-sales service when a product is very high-tech. You and I both had a lot of assistance, Matthew, with setting up the high-tech in this room today. But if you were taking that home, I think I would definitely need a good pre-sale service. But I think in coming on to, you mentioned that the review that's going on at present, one thing I would hope they would look at is whether in the current retail environment, it's more appropriate for a wider range of brands to be able to benefit from selective distribution, regardless of their market share. All brands are investing in what makes that brand. And particularly with the advent of online, they need more tools to be able to protect that.
Yeah, I think it's important to note that as you mentioned, that even though selective distribution is seen as this specific area, you still can't impose these hardcore restrictions in that type of arrangement. And also you mentioned if you're above 30%, that I think the point you're making there was that the block exemption is so important because it captures any type of selective distribution arrangement, even if you're below 30%. So if you're below that, there's really a lot you can do with any type of product.
Exactly, yeah. There's these block exemption will cover a selective distribution system regardless of the nature of the product. That's sort of the plain wording. So you don't have to think, well, this is a luxury product, this is a high-tech product. It's just have you selected your criteria, you're selecting your resellers according to that criteria and saying that they're the only people who can sell your products, and that's it, and you're under 30%.
As long as you're under 30% at purchaser and at supplier level, you're fine. So that's such an important point. We looked at, we mentioned the object and hardcore restrictions, RPM, and restrictions on trade within the EU. Looking at the online world, where a lot of these cases are now popping up, this concept has moved into what is a hardcore restraint online? What is an object restraint online? What are some of the provisions which have been held to be effectively hardcore or object restrictions in the online selling world?
Well, a lot of online sales bans have been, particularly where there are brand owners who are seeking to control price. They think if they stop their products being sold online, or if they alone have the online presence, what they're really trying to do is control pricing. And that kind of arrangement, one would expect to be hardcore. And you see that in the PFR case, for instance, an older case where it was a cosmetics products, wasn't it? And they were saying you need a pharmacist to be present to sell these goods, as in you're only going to get that in bricks and mortar store. And I think what was going on there was they didn't want online sales, and they didn't want the brand erosion that they thought was going to come from the online environment. But things have certainly moved on. I mean, that case must be at least 30 years old now. The recent case of Coty, I'm sure, is one you're aware of, where they were looking at bans on third-party marketplaces. So where third parties are selling on a sort of auction website or what have you, is it appropriate to stop your products being sold on those third-party marketplaces? And the Coty case that went to the Court of Justice of the EU, so that's our highest court, 2 years ago, found that was permissible. You're not in those circumstances preventing somebody having an online presence. Still the majority of the traffic in that case was on resellers' websites. You've still got the search engines and so on to create more visibility. So that was permitted. In that case, there was a selective distribution system operating, and that criterion was acceptable.
Yeah, that's a huge case, as you say. And Coty finding that marketplace bans are not object restrictions. And the Commission has come out and said that actually should apply across all types of products as well, not only in the selective distribution world. So it's a very important kind of benchmark.
Or not just luxury products.
Not just luxury products, What about, I think there's some other online restrictions which have been held to be hardcore. What about just indicating a minimum price online? If you're restricted from the price you can advertise online, has that given rise to some concerns as well?
Yes. So as we said in the basic principles up front, you can't set the minimum price, you can't set the fixed price. And also in terms of what you're advertising, if you can't show that that you've got a sale going, if you can't invest in that sale by promoting it, then what's the point? The incentive to discount is massively reduced. That's how the online world works.
Yeah, exactly. So I think we've touched on some of these cases. Coty is a bit of an older case, but just in the past year or so, there have been quite a few interesting cases from the European Commission.
Definitely.
We can focus on the Commission cases. There have been a lot of national cases as well. But if you focus on the Commission cases, there's a recent one which caught my eye, which seemed to capture a whole load of problematic restrictions, which was the Guess case.
Oh, yeah, definitely. I mean, it's interesting to see. I think if you look back 5 years ago, 10 years ago, the Commission wasn't very active in this space. And it was being left to the national authorities, which of course left quite a lot of divergence. So there was a different approach being taken to the third-party marketplace bans, for instance. So I think it's great that the Commission and the European courts are sort of weighing in more. And Guess was a paradigm case of that. So Guess, the clothing retailer, had, I think, online sales ban. It was trying to drive all of the online traffic to its own site. It had AdWords restrictions, which perhaps we can come back to, and sort of really classic resale price maintenance issues. So I think that kind of messaging from the European Commission level has been really important. And part of them doing more, they did of course, e-commerce sector inquiry in 2000 and concluding in 2017, which I think gave them enough information to feel more confident weighing in and taking this kind of enforcement action.
Yeah, that's an interesting point you make. The e-commerce inquiry, if anyone is interested in the area, from 2017 is a great document to look at. It goes into all of this in a lot of detail.
It's a thrilling 300 pages.
Well, it's a thrilling document. Yeah. You can do keyword searches if you don't want to read the whole thing, but there's a lot in there. And as you say, a lot of these cases have come out of that. Really, before 2017, there'd hardly been any vertical infringement enforcement from the Commission for a long time. Then this inquiry came out, and since then there's been a whole load of things.
Yeah.
And what about the Nike and Sanrio cases, which were also from earlier this year?
Interesting ones. So I think a €6 million and €12 million fine for in the vertical context. They were licenses rather than pure distribution agreements. So licensing the Hello Kitty brand and creating exclusivity around that licensing and cross-border restrictions. So sort of we license someone in France to produce the Hello Kitty products, and they mustn't sell outside of France. That kind of absolute territorial restriction doesn't work in Europe. But what you did see there, I think in both cases, was a 40% reduction on the fine because of the cooperation. And you see that in quite a lot of these vertical cases at the Commission level. And it's new, this possibility for a reduction. And I think that's a really great development as well, to see the commission exploiting efficiencies. Obviously, cooperation creates a lot of efficiencies, and 40% is a good incentive. You necessarily waive a lot of your defense processes in cooperating like that, and I think the commission's really making it worthwhile for people.
Absolutely. The leniency provisions in the pure cartel world are very well known, but as you say, these cooperation benefits outside that are also very important now as well. And the other point you mentioned in relation to those two cases is that they were licenses and not just pure buy-sell distribution agreements. So showing that these principles can often apply in that area as well, and not just pure distribution. Yeah,
something like licensing a trademark is often IP will give you more scope to do things with, if you've got some copyright, maybe you've got some marketing materials that are copyrighted, or there's more scope in that kind of world. But if you're just talking about a trademark, really it's just the usual distribution principles that apply.
Yeah. And what about there's some consumer electronics cases earlier this year as well, which were finding straight resale price maintenance online. I think that was really the commission going full throttle on that issue and finding a number of those companies.
Quite classic infringements. I don't think there was, as European competition lawyers, I don't think there were any principles we were surprised about that. No. But what you really see, that was, I think, 3 cases announced at once. That was the commission saying, we're back in this vertical space, we are going to enforce it, and trying to really up the awareness, I think, of these of RPM issues, cross-border sales restrictions, particularly if you come across a company that has expanded into Europe and maybe ported their agreements across Europe. These are the pitfalls.
Right, absolutely. We've seen a lot of other issues as well. We've seen some cases on geo-blocking, and there's the geo-blocking regulation. What is geo-blocking? What is geo-blocking all about?
Well, I think it means different things to different people. You could say that some of the cases we just talked about involve geo-blocking, because with the licensing arrangements and so on, they're creating a cross-border restriction. The geo-blocking regulation specifically, so to my mind, is quite an invasive piece of legislation that could have done with a bit more scrutiny. But essentially, it's not just, you mustn't put that kind of cross-border restriction in your agreements, in your distribution agreements, your license agreements, but you must, but yourself as a company, not offer your products cross-border, not necessarily pay extra take the onus of the delivery costs on yourself. But yes, you must be offering it around Europe, which is, I think, quite burdensome, quite challenging to people in different regulatory environments.
This has been actually a very, very educational experience for me. I was wondering if I could ask a couple of questions about how we might compare where things are in the U.S. and where things are in Europe. Well, let's start at the top. So in the U.S., you could have what we call resale price maintenance, which means you could go online, and it's the reason why you see, if you want to buy a barbecue grill, all the grills across all the websites for this one particular brand would be the same price. We do that in the U.S., and that's overall reason or by effect. Europe, it's different, right?
Yeah, exactly.
A scale of really super good to super bad.
It's right up there as our most problematic one of our most problematic vertical restrictions. One of the most obvious, the fining issue. Many vertical restrictions that you put in, the exclusivity is too aggressive, are less obviously likely to land you with fines. RPM, resale price maintenance, is a fining issue.
Okay, so that one's bad. What about if I were a manufacturer and I said to my distributors, okay, I'm going to use U.S. geography, but you distributor 1 can distribute only east of the Mississippi River, and you distributor 2 can distribute only west of the Mississippi River. If I did the same thing in Europe with, say, France and Germany, again, scale of super good to super bad.
Definitely less bad than the RPM. So you can, what you need is exclusivity to create some kind of geographic differentiation like that. So you should give distributor 1 France exclusively, distributor 2 Germany exclusively, and then you can tell them not to actively market into each other's territories. They need to be investing in marketing in their own territory. You could not, however, stop the passive sales, the unsolicited sales cross-border.
Okay, okay, now if I said to distributor 1, you can sell only to customers 1 to 10, and distributor 2, you could sell only to customers 11 to 20. Again, scale of super good to super bad?
Pretty much the same as the last one. You just need to allocate them exclusively so that distributor 1 is investing in that relationship with distributors 1 to 10. And again, you then could stop the exclusive sales across customer groups. You could not stop the passive unsolicited sales across customer groups.
Okay. How about this one? I want to go out to my distributors and say, you should buy into my promotion, and I'm going to support you with promotional dollars. But if you advertise our product, you can't advertise below this minimum price. You can sell it for whatever you want. I don't care. But you can't advertise below this minimum price. Super good, super bad.
That's really just RPM again, I would say. If you want to do a campaign where you support people with, you give them some money to support the discount, then I would set it as a maximum. We're allowed to have maximum prices.
Okay.
That's IMAP. That's IMAP, John. IMAP. It's seen as RPM, as Jen said.
So super bad in Europe, super okay in the US.
Yes.
Okay. All right. Well, this has been really, really helpful. Jen, it's obvious you enjoy being a competition lawyer. What is it about being a competition lawyer that you like?
I think the fact that we have to understand the client's businesses so well to advise them. You know, we always do these deep dives into companies' distribution structures before we try and tell them anything that they might be able to improve in Europe. And the scope to be sort of innovative and creative with some of these strategies, because it's an evolving area. I mean, there's going to be a whole load of new opportunity as this verticals consultation progresses to come up with new creative strategies then.
And if you could get into your time machine and go back and meet the 25-year-old you, what advice would you give you?
Chill out. Yeah, but work those hours if you want to, but don't take it all too seriously as well.
Okay, so tell us something about yourself that we wouldn't know if we just knew you professionally. Something unusual, different.
Well, my first job that I held on to for any length of time was in Munich, in southern Germany. I worked in a beer hall right by the foot of the Frauenkirche, for anyone who's been over there, in the center. So, carrying the steins around and things. So that was a big change when I started my training contract.
When you were there, did you go through Oktoberfest?
I was just coming back then, so yeah, I think I'd stopped work, but I did go and I went back for Oktoberfest as a paying customer. As
an American, one of the things that has kind of confused me is sometimes you go to Germany and they'll advertise Oktoberfest, but it's in September. Have you ever noticed that?
Yeah, definitely. Well, as a good old Oxbridge graduate, I also noticed that May week, when we have all our parties, somehow got shoved into June, and you're just sitting exams in May week when we're meant to be having May balls.
So is the idea that the Germans are very prompt, and so they want to be on time, so they schedule Oktoberfest in September, but the Brits?
Maybe that's it. That makes a lot of sense. You've just explained it to me, John.
Okay, and just grabbed a couple of stereotypes there, John.
Yeah.
It works.
So maybe I'm not going to be able to help solve the European diplomatic problems. Okay, note to self. Let's do our last segment, which we call the Curious Hat.
And now it's time for the Curious Hat.
And Curious Cat, we have a number of questions that we've written. There are in an actual hat. And I'm going to choose a question for you and ask you. This is being done completely at random. And we've chosen question number 20. Who is someone that you look up to or greatly admire?
I would say I can't help it. I'm going to have to go for the politicians. So I would say, John Major or somebody like that, who was never. I don't know if he's popular in the US. He was never popular here. But looking back on that kind of principled politician through lots of. He's had a lot of forces blowing the other way, and I think he's quite consistent in how he speaks up for the royal family, and he sort of speaks up for the way our politics is going, I would say.
And what impact do you aspire to have on others?
Well, I guess for clients, to make their lives easier, for colleagues. To help us all enjoy our jobs more. If you get on with your colleagues, then, and we're all enjoying ourselves more, then hopefully we're doing a better job, and everyone's happier to be there.
Okay. Well, I think that will do it for this week. Thanks again for listening, and we'll see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.org. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.